Louisiana has a unique breaking lease framework shaped by its civil law legal system, derived from French and Spanish traditions, making Louisiana distinct from every other state. The governing law is found in the Louisiana Civil Code provisions on lease, particularly Articles 2668 through 2729, along with general civil law principles. If you're a landlord or tenant in Louisiana, understanding how the civil law approach affects early lease termination is important, because the legal reasoning and terminology differ from the common law system used in the other 49 states. Let's start with the basics. Under Louisiana's Civil Code, a lease is a synallagmatic contract, meaning both parties have reciprocal obligations. The tenant is obligated to pay rent for the agreed-upon term, and the landlord is obligated to provide and maintain the premises. A tenant who breaks the lease before the end of the term is in breach of their contractual obligation and is generally liable for damages. The landlord's duty to mitigate damages in Louisiana is rooted in the Civil Code's general obligation principles. Under Louisiana's civil law framework, the injured party in a breach of contract, the landlord, has a general duty to act reasonably to minimize damages. This means the landlord cannot simply leave the unit vacant and collect the full remaining rent without making efforts to re-rent. Louisiana courts have applied this mitigation principle in landlord-tenant cases. The landlord must take reasonable steps to find a replacement tenant, advertising, showing the property, and accepting qualified applicants. The departing tenant's liability is reduced by whatever rent the landlord collects or could have collected through reasonable efforts. The specific application of the mitigation duty in Louisiana follows civil law reasoning. Courts look to the code provisions and doctrinal principles, rather than building rules through case-by-case precedent the way common law courts do. However, the practical result is similar. The landlord must try to re-rent, and failure to do so reduces the departing tenant's liability. Early termination clauses are enforceable in Louisiana under the Civil Code's general freedom of contract principles. The parties can include a clause pénale, a penalty clause, in the lease that specifies the amount the tenant owes for early termination. Under Louisiana Civil Code Article 2005, a penalty clause is enforceable, but the court has the authority to modify a penalty that is so manifestly unreasonable as to be contrary to public policy. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and enforceable. A clause imposing the full remaining rent as a penalty, without accounting for mitigation, could be modified by a court to reflect a more reasonable amount. Louisiana courts have more authority to modify penalty clauses than courts in some common law states. The Civil Code tradition gives judges broader discretion to adjust contract terms that produce unjust results. Louisiana also has the concept of tacit reconduction, where a lease automatically renews on a month-to-month basis when neither party acts at the end of the term. This is relevant to the breaking lease context because a tenant who remains past the original term without a new lease is on a month-to-month basis, and terminating a month-to-month tenancy requires only 10 days' notice under Louisiana law, not a lease break. Military members have the right to break a lease under the SCRA. Louisiana has a significant military population. Barksdale Air Force Base, near Shreveport; Fort Johnson, formerly Fort Polk, near Leesville; Naval Air Station Joint Reserve Base, New Orleans; and Keesler Air Force Base just across the border in Biloxi, Mississippi, all generate military rental demand. SCRA terminations are regular occurrences, particularly near Fort Johnson, which is a major training installation with constant personnel turnover. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No penalty clause or early termination fee applies. Louisiana does not have a specific state statute providing enhanced lease-breaking protections for victims of domestic violence in the detailed framework found in states like Oregon, Washington, or Massachusetts. Louisiana does have the Domestic Abuse Assistance Act, which provides protective orders, and the Protection from Dating Violence Act, However, these laws do not include a specific provision allowing early lease termination. Domestic violence victims in Louisiana who need to break a lease must generally rely on general civil code principles, including arguing that the lease should be dissolved due to changed circumstances that make continued occupancy unsafe. Negotiating with the landlord or seeking assistance through advocacy organizations like the Louisiana Coalition Against Domestic Violence provides practical alternatives. Some Louisiana landlords voluntarily include domestic violence termination clauses, which is a recommended best practice. Tenants in Louisiana may break a lease if the landlord fails to maintain habitable conditions. Under Louisiana Civil Code Article 2696, the landlord is obligated to maintain the leased property in a condition suitable for the purpose for which it was leased and to make all necessary repairs during the lease term. If the landlord fails this obligation, the tenant has remedies under the Civil Code. Under Article 2700, if the property requires repairs that cannot be postponed and that substantially deprive the tenant of the use of the property, the tenant may obtain a reduction in rent or dissolution of the lease, depending on the circumstances. Dissolution of the lease is the civil law equivalent of lease termination. The court orders the contract dissolved and the parties released from their remaining obligations. The tenant should provide written notice to the landlord identifying the specific deficiencies and requesting repair within a reasonable time. If the landlord fails to act and the conditions are serious enough, the tenant can seek judicial dissolution or can argue that the landlord's breach justifies the tenant's departure without further obligation. Louisiana also recognizes the concept of force majeure, an event beyond the party's control that makes performance impossible or impractical. Hurricane damage is the most relevant application of force majeure in Louisiana's breaking lease context. When a hurricane damages a rental property to the point of uninhabitability, the lease obligation may be suspended or terminated. Under Civil Code Article 2715, if the leased property is totally destroyed, the lease terminates. If the property is partially destroyed, the tenant may obtain a reduction in rent or dissolution depending on the extent of the damage. This provision is critically important in Louisiana, where hurricane risk is a constant factor across the coastal parishes and increasingly inland. The aftermath of Hurricanes Katrina, Rita, Laura, Ida, and other storms has generated extensive litigation over lease obligations when properties are damaged. The general principle is clear. If the property is uninhabitable due to storm damage, the tenant's lease obligation is suspended or terminated. Landlords cannot enforce lease terms against tenants displaced by hurricanes. Louisiana's 10-day notice period for terminating month-to-month tenancies, one of the shortest in the country, affects the breaking lease context. If a tenant is on a month-to-month arrangement, either because the original lease expired and renewed by tacit reconduction or because the tenancy was month-to-month from the start, the tenant can terminate with just 10 days' notice. This is not a lease break. It's a lawful termination of a month-to-month tenancy. Tenants and landlords should be clear about whether the current arrangement is a fixed-term lease or a month-to-month tenancy. The difference in termination requirements is significant. From a practical standpoint, Louisiana has a diverse rental market with distinct regional dynamics. New Orleans is Louisiana's most prominent market. When a tenant breaks a lease in New Orleans, re-rental depends heavily on the neighborhood. The French Quarter, Garden District, Marigny, Bywater, Uptown, and Mid-City have strong demand. Landlords can typically re-rent within 2 to 4 weeks. Other neighborhoods have more moderate demand. New Orleans' hospitality workforce represents a large portion of the tenant population, and these workers may break leases due to job loss, reduced hours, or relocation to follow seasonal employment opportunities. Pursuing the full remaining rent from a hospitality worker who lost their job and left is often impractical. Prompt re-rental is usually the landlord's best financial outcome. Baton Rouge has a moderate market driven by state government, LSU, healthcare, and the petrochemical industry. Student lease breaks at LSU follow the academic calendar. Spring and summer departures fill quickly. Shreveport's market is influenced by Barksdale AFB. Military lease breaks are routine. Lafayette's market fluctuates with oil and gas prices. Fort Johnson, near Leesville, generates constant military turnover. The base's training cycles create predictable lease break patterns, and landlords in the Leesville-DeRidder area should treat military lease terminations as a routine part of operations. Lake Charles experienced significant disruption from Hurricanes Laura and Delta in 2020. The rebuilding process has affected the rental market, and tenants displaced by storms may have gaps in rental history and credit impacts that are entirely storm-related. One best practice for Louisiana landlords: understand Louisiana's civil law terminology and framework. Terms like dissolution, clause pénale, tacit reconduction, and force majeure have specific legal meanings that differ from common law concepts. If you use standardized lease forms from other states, have them reviewed by a Louisiana attorney to ensure they comply with the civil code. Another best practice: have a hurricane plan that addresses lease implications of storm damage. After a major storm, communicate promptly with tenants about property status, expected repair timelines, and each party's obligations. If the property is uninhabitable, acknowledge the situation and work toward a fair resolution. A third best practice: document your mitigation efforts whenever a tenant breaks a lease. Even though Louisiana's framework is civil code rather than common law, the obligation to minimize damages exists. Keep records of listing dates, advertising, showings, and when you accepted a replacement tenant. Louisiana does not have a statutory cap on security deposits. The deposit amount is governed by the lease terms. The deposit must be returned within 1 month of lease termination. If the landlord fails to return the deposit within 1 month, the landlord may be liable for penalties. These rules apply whether the departure is a normal move-out or a broken lease. For the complete guide to Louisiana breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.